Thank you, Professor Kim. It's quite a pleasure that I come back to Schumpeter Society meeting after probably more than 10 years, and I wish to thank Professor Kyung Lee for inviting me to this very precious opportunity. And as Mr. Professor Kim mentioned, I was in the past 7-8 years, I've been more involved in competition policy in Japan. I was at the Japan Fair Trade Commission, part of the government, and so I became very much interested in this issue of innovation and competition policy. Innovation and competition policy, that's what I'm going to talk about today. Because this is the Schumpeter Society meeting, let me start with Schumpeter. Actually, this is also the one that Lord Sainsbury cited this morning. I realized that Schumpeter says in 1942 in his famous book, Capitalism, Socialism, and Democracy, it is still competition within a rigid pattern of invariant conditions, methods of production and forms of industrial organization, in particular that practically monopolizes attention. But in capitalist reality, as distinguished from its textbook picture, it is not that kind of competition which counts, but the competition from the new commodity, the new technology, the new source of supply, the new type of organization, and so forth. Some people tend to think that this kind of statement by Schumpeter means that competition is not so favorable condition for innovation, and monopoly situation is more suited in innovation. But I don't think that is quite true. And in fact, not the textile perfect competition, but the more severe kind of competition that Schumpeter had in mind. That's what my understanding. And in that sense, it is quite relevant to competition policy today. It is true that competition authorities still consider that to analyze competition with a rigid pattern of invariant condition is important, but it is not all. In terms of theoretical model, now rarely is it a perfect competition model, but game theory-based oligopoly models without product differentiation that the competition authority uses. And rarely is it a single closed market that competition authority looks at. Authority looks at the competitive threat from entrants and neighboring markets. So we do have much wider views. And competition authority also looks at the impact on innovation. And by many studies, innovation is now known to have a kind more or less inverted U-shaped relationship to concentration. As Schumpeter mentioned, perhaps it is true that the introduction of new methods of production, new commodity is hardly conceivable with perfect competition. Because in the perfect competition, the firms are assumed to be price takers. And in that sense, they do not have much incentive to innovate. But it is also true that innovation is unlikely to be undertaken by monopolies without competitive threat. Because, again, as Schumpeter said, it must be that a monopoly position is in general no cushion to sleep on. And also, economic theory these days suggests that there's a certain replacement effect or cannibalization effect to the monopoly, and that reduces a monopoly's incentive for innovation, right, not for competitive threat. So competition is important, and with that in mind, let me say what competition authorities do today. In terms of collusion by competitors on prices, which is usually called hardcore cartels, is strictly prohibited. But collaborations for innovation activities are permitted unless they have anti-competitive effects. The examples are R&D collaborations, possibly between competitive firms, patent pools, standard setting. In those cases, collaborations among competitors is common, and that mostly permitted by the competition authorities. In terms of merger reviews, the probable effects on innovation are often considered. So, for one thing, a merger may eliminate rival innovators, reducing competition in the what's called innovation market. In a very recent decision by the European Commission on the Bayer-Monsanto consolidation, the EC said that the transaction would have significantly reduced competition on price and innovation, and therefore they have required certain remedies for this. A merger also may combine the firm's intellectual property rights, such as patents, thereby making the access to technology difficult for rivals and entrants, reducing competition in the what's called technology market. And in those cases, this has happened several times, and in those cases, competition authority may require licensing with what's called upfront condition as a remedy. I'll talk about this upfront later. Now, the patents and competition policy, it has a certain difficult relationship in a sense, because theoretically patents promote dynamic competition, but on the other hand, restrict static competition. However, because of this promotion of dynamic competition, the use of exclusionary power with the patent is in principle accepted in most countries. For instance, in Japan's Anti-Monopoly Act, AMA, it says that the law shall not apply to such acts recognizable as the exercise of rights under the IP laws. However, still, Japan Fair Trade Commission, which you say JFTC published what's called IP guidelines. And in that guideline, it said that any act that may seem to be an exercise of a right cannot be recognizable as the exercise of the rights provided for in the aforesaid Article 21, provided that it is found to deviate from or run counter to the intent and objectives of the intellectual property systems. So in that sense, it's more on a case-by-case basis. The competition policy may do certain actions against the use of the patents. In fact, many patent-related issues have become very important in recent decades. And this I will talk soon. But before going that, let me talk a little bit about competition policy in Japan in general, because my understanding is that not many of you are familiar with the Anti-Monopoly Act or competition law in general. Basically, the Anti-Monopoly Act prohibits 4 types of behaviors. The first 3 are these: private monopolization, which is exclusion and control; unreasonable restraint of trade, basically cartels and bid riggings; and the third is unfair trade practices. These 3 are considered to be anti-competitive conduct, and that is prohibited. And the fourth one is more the prevention of the formation of anti-competitive market structure, that is to prohibition of the business combination that restricts competition. And to carry out these Anti-Monopoly Act, in the case of Japan, we have an organization called Japan Fair Trade Commission, JFTC. It consists of the chairman and 4 commissioners. I was a commissioner, one of the commissioners from 2012 to 2016. And I should perhaps mention that my predecessor at JFTC was Akira Goto, and some of you may be familiar with him because he was also a regular visitor to this society. And current commissioner, my successor, is Professor Reiko Aoki, who has been also making lots of studies on I/O issues and innovation, patents, and so forth. So again, some of you may be familiar. So in the past 15 years or so, at least one of the commissioners was an economist with not much knowledge on patent innovation and so forth. The JFTC has an administrative staff of about 830, which is very big among the commission authorities. Now, in the rest of the talk, I'm going to talk about the patents and competition policy. There have been a number of important issues in this relationship, So I'm going to talk about those things, but for this purpose, it is quite convenient or important to distinguish three types of technology. What's called discrete technology, collective technology, and cumulative technology. In the discrete technology, it's a stand alone. So basically from one technology, one product can be produced. And main example is pharmaceuticals. The second one, collective technology, requires numerous technologies like T1, T2, T3, etc. To get to the product. And most of the recent industries like electronics, communication equipment, automobiles, in those industries, it's a collective technology and a number of technologies have to be cleared to get the product. Now, the third one is cumulative technology, in which the technology is used as an input for further technology development. Out of T1 comes from T2, and then the product X. Main example is the research tools, and this has happened in electronics as well. And for each of these three types of technology, there has been issue related to competition policy. Now, the first one, discrete technology. In principle, the clearance of a single patent enables production and sales of the product, such as a drug. And so, when this patent protection ends, imitators tend to end very rapidly. That is, in the case of the drug industry, it's a generic producers coming into the market. The monopoly profits will be lost rapidly after this entry, and therefore the monopolists, that is the patent holder, tend to have an incentive to pay, or I would say bribe, potential entrant to prevent or delay the entry. This is the behavior usually called pay for delay or reverse payment, RP. It is a reverse payment because, again, it's the other side of the royalty. Royalty is paid from the licensee to the licensor, but in this case, it's a payment from the patent holder to those companies using that technology. Now, this rapid reverse payment took place basically in the pharmaceutical and basically in the United States. And why is that? The reason that it is in the pharmaceutical is that in this industry, the patent is very strong. As many of the survey studies suggest, what's called appropriability is high in this industry. But once the patent expires, imitation is relatively easy. And then price decline after the entry of generics is rapid. Now, why it took place often in the United States? That's because of the US regulation. Under the US system, an entrant can claim the invalidity of the patent and apply for government approval while the patent is still in effect. And the second one is that the first entrant is awarded the 180-day exclusive period. And in that sense, generic firms have an incentive to apply first to get this preferential treatment. And then they can apply for the government approval while the patent is still in effect, claiming that the patent is invalid. And because of that, many reverse payment has taken place in the United States. And because this reverse payment delays the entry of generics, that is against the consumer's interest, that would reduce consumer surplus. And therefore, it is usually considered to be anti-competitive. And the US Fair Trade Commission, US Federal Trade Commission, sorry, the US FTC has taken actions against those cases. But there's a big issue in this relation. Some argue that to pay to get the delay for the entrant, that is also within the patent holder's right. There's an argument of that sort. And in fact, at one time at least, in the United States, court decisions varied across courts So there is a one quotation saying that the reverse pay for delay is within the patent rights, and therefore it is not against antitrust law. And another discussion said that the mere fact that it delays entry is anti-competitive. And therefore there were certain disputes about that, and finally the Supreme Court said it's basically it's rule of reason. That is, it's case by case. So this is a very delicate question. Now let me go to the cumulative technology, and in here a licensee may invent and improve, modify, or additional technology based on the original technology and patent it. And with that possibility in mind, it can happen that the licensor requires the licensee to assign the patent of such improved technology to the licensor, which is called grant back. Or the licensor may require the licensee to promise that the licensee does not assert the patent right to the licensor, and so forth. This is called non-assertion of patents, or NAP. And this behavior may be considered anti-competitive. Again, if I quote from the JFTC's IP guidelines, it says that when a licensor imposes on licensees an obligation to refrain from exercising the rights owned to be acquired by them against the licensor or any entrepreneur designated by the licensor, this obligation could result in enhancing the influential position of the licensor in the product or technology market, or could impede licensees' incentive to engage in research and development. And this latter part, impediment to the licensee's incentive to engage in research and development, was considered to be very important in the case that I quoted here. JFTC decided in 2008 that Microsoft's NAP clause constituted a violation of the Anti-Monopoly Act. Here is a basic picture of that case. Microsoft licensed the OS technology, which is Windows, with an NAP clause to the PC makers. And PC makers then invented technology to improve the audio-visual effects to be used on the PC. So for instance, PC maker B invents such improved technology, but because of the NAP clause, Microsoft may copy that, PC maker C and D may copy that, and PC maker B cannot get any license fees, or they cannot, in that sense, differentiate its product from other PC makers because every other PC makers can use the same technology. So because of that, PC maker B would not have much incentive to spend for R&D to improve the technology. And that was considered to hurt consumers in the long run, and therefore this was considered to be against the Anti-Monopoly Act in Japan. Now, let me go to the third one, collective technology. In industry with collective technology, standard setting often becomes very important owing to the presence of network effects. Accordingly, the clearance of numerous standard essential patents, the so-called set, is needed. However, for those SPP, royalty stacking, that is, paying numerous royalty to numerous licensors, that would amount a very big amount, and because of that, the product may not be produced at all. That kind of problem can happen. These are called royalty stacking and the tragedy of anti-commons. And also what's called the hold-up problem may take place. As an effective solutions, patent pool and FRAND has been devised. FRAND means that the patent holder's commitment to license with a fair, reasonable, and non-discriminatory conditions. These are considered to be effective, but each of that has certain problems. For patent pools, it is considered to be effective to avoid royalty stacking and to reduce transaction costs. But the outsider problem can take place, because staying as an outsider is, will make you more powerful in your bargain with the licensees. So that outside the problem can make it difficult for the patent holder to agree to form a patent pool and set an aggregate royalty rate. And in fact, in more recent years, there haven't been that many patent pools organized. Patent pools are in principle considered not a violation of Anti-Monopoly Act, even though they may be a collective action among competitors, except when the competitors jointly decide a product price, etc., or when the patent pool was used to refuse licensing to particular market participants or to new entrants. And this kind of prohibition of licensing to new entrants took place in Japan now almost 20 years ago in what's called the pachinko machine manufacturer patent pool case. But not many of you know about pachinko. It's a game machine, and you will see that it is quite high-tech these days. Even in 1997, the patent pool had something like 2,000 patents related to this. Now, F-brand. Standard setting organization, that is SSO, now widely requires set holders to declare licensing with F-brand conditions. However, again, there are a number of difficulties. For instance, patent holders are tempted to include non-ancestral patents in here to increase their license revenues. Or the patent holders may stay as an outsider to avoid F-brand declaration. They may sell the patent rights to outsiders, like patent assertion entities, what is usually called PAEs, who may demand non-reasonable high license fees. And of course, interpretation of F-brand is difficult. Now, in terms of non-discriminatory, actually in Korea, in here, there was a case involving Qualcomm in 2009, because Qualcomm charged different license fees to those who also purchased Qualcomm chips and those who did not buy those chips. That's the KFTC considered to be anti-competitive and took an action. And also, what is fair and rational, that is also very difficult to interpret. And JFTC revised the IP guidelines 2 years ago, and it said that the refusal to license or bringing an action for injunction against a party who is willing to take a license by a F-brand encumbered stepholder may be considered a violation of Anti-Monopoly Act. The big question is how to interpret the word who is willing to take a license. If the licensee, prospective licensee, is saying that the license fee required by the patent holder is too high and we cannot pay that. If the prospective licensee insists on that, then can we say that it is that willing to take a license or not? That's a very difficult question. There was one case actually, very recently. So this is November 2017. There was a case called One Blue, which is a patent pool for Blu-ray discs. And in this case, JFTC that the demand by One Blue is anti-competitive. But in this case, there was a court case, private litigation, before JFTC made any decision. And in this private litigation, court said that the party is willing to take a license by an F-brand holder. So that is why the JFTC could take an action. But in general, although we have this guideline, usually I believe it is very, very difficult to decide if the licensee is willing to take a license. So as you can see that in all of these cases, the cases involving the patents, competition policy is involved, but sometimes the decision is very delicate and very difficult. So let me stop my discussion here. Thank you very much.